will be sharing my time with the agreement of the House with Deputy McConalogue. At the outset, I have to put on record of the House the annoyance on this side of the House of the failure of the government to introduce the bill in a timely manner. This was introduced in the Seanad some 2 years ago, and 2 years have elapsed and absolutely nothing was done until the 2 vessels were apprehended, and of course then we have to deal with this as a matter of urgency. And Minister, I would have to challenge you here in the House that both in interviews, this is not perception, you give an interview to RTE, you give an interview to a national paper, and you pointed the finger across to this party to say that we were responsible for the delay and for you having to withdraw it in the Seanad. That's not a fact. And I would ask the Minister to deal with that. It's not a political charge, but it's a factual one. I'm referring to the article, the RT interview and the newspaper interview, and back in December of this year. So this should have been dealt with, and the blame has to be laid at the foot of the government, and particularly this Minister, who decided that this would evaporate until such time as the vessel was apprehended. So that's why we're here today, rushing this legislation through. So we in this side of the House, we accept the principle of this, and to correct this historical failure to underpin the agreement of Taoiseach Sean Lemass and Captain Terence O'Neill back some 50-odd years ago. And it was beneficial to small vessels on both sides of the border within the 0 to 6 zone. This has been, of course, we're here now because of the decision taken by the courts, who said that while they accepted that there was an informal agreement there, that it had to be underpinned by primary legislation. Can you confirm to this House, when you're responding, Minister, that is the view of the courts that the Voisinage agreement does not distinguish between sea fish and aquaculture? Further, is it correct to say that it is the view of the judgment against the state in effect of the Voisinage agreement covers all species, or not just sea fish? Because when this was established, first of all, it referred to sea fish and sea fish only. And of course, in the 1990s, there was a practice that had extended to other activities such as aquaculture and non-quota species. Could I also ask you to confirm to the House that the Supreme Court judgment does not differentiate between the species in terms of interdependence on the Voisinage agreement and what is permitted to fish under the terms of that agreement? Can you also ask that the same interpretation is taken by the UK authorities in terms of what is permitted? It is clearly the case, I believe, that the greatest area concerned is not necessarily sea fishes, but indeed it's the mussel seed fishing. And I have to express my concerns in relation to this also. And today we have a Donegal man on hunger strike outside the gate. Both myself and Mr Deputy McConalogue took the opportunity to meet with his brother because of the sub judice rule, and we met with the brother, who is very, very well versed. And I would ask you, Minister, and I'm sure you were asked in the Senate, that you could afford the courtesy to meet with that person before the end of the day and take on board the concerns which you have. Can I also ask you, Minister, you're satisfied if we enter into this agreement that the mussel seed resource of this state can be protected in a sustainable way? I'm not so sure if anyone has any details on the state of the mussel resource, and I think it's important to have that. And if we can't have anything included here now, we must make sure that there's management there and that resource is not decimated to the expense of those who have been fishing it over the years. Minister, you made reference to meeting various UK government ministers, and they have said to you, to put this, are you going to put it on a legal footing? I have to ask the question, is this on a legal footing in the UK? We can't, of course, question the judgment of the courts, but perhaps you might be able to tell us if there are plans by the various ministers, whether it's Minister Goodwill or Minister Gove, if they're prepared to do that. Do you, Minister, have any plans under the 2006 Fishery Amendment to introduce management measures? And if so, what type of management measures are you considering? Will those management measures apply to all non-quota species and/or aquaculture? Despite having 2 years to proceed with this bill, and I'm quite sure, Minister, if you took the opportunity at the time that you withdrew from the Senate and you found that a lot of progress was made as a result of meetings requested by opposition spokespersons, where we met you in your office on 2 occasions, when we insisted that telephone calls on a Wednesday evening was not consultation, and you did eventually concede to have consultation in the Department's office in Clonakilty. There were those who didn't have the opportunity, and it's unfortunate that they didn't have the opportunity, because some of those who went there are possibly more seriously affected than the others. Would you also, when you are responding, refer to the 18-metre restriction? Does it only apply to sea fisheries and not to aquaculture activities? So I want to give an opportunity, to my colleague Charlie McConalogue, but I would hope that during the course of the committee stage that we'll have an opportunity to ask more specific questions.